Johan, what we do here a lot is, if people ask me about levy statements, is what is this CSOS levy and what does it stand for? Why do I need to pay it? So maybe you can just shed some light on that.
100%. Amoré, yes. In the last couple of years, and I'm talking about since 2011 right through 2016 and onwards, we received considerable more legislation governing community schemes, sectional titles, homeowners associations. Because if you think about it, that up until CSOS, and we'll explain to the participants in a moment what that means, but until then, we basically had no legislation except for the Company Act that regulated homeowners associations. And that was a huge pitfall that we needed to address, because there needs to be a specific forum where people can declare disputes and where these disputes can be resolved. If you think about it, I mean, the insurance industry has an ombud. The motor industry has an ombud. The banking industry has an ombud. And the question is, why don't security complexes or community schemes have an ombud either? And that was addressed by means of the consumer tribunal itself, and it was also addressed by means of the Community Schemes Ombud Service, and that's what CSOS stands for. So the Community Schemes Ombud Service Act 9 of 2011 saw the light around about 2011. And the whole idea is that any owner of a unit or a house in a, call it an estate or security estate or body corporate, can declare a dispute with its homeowners association, and that can be resolved by the statutory body called CSOS, or the Community Schemes Ombud Service. Now, it is a physical office that is situated in Sandton, adjacent to the Estate Agency Affairs Board, and it's governed by qualified legal personnel that basically determine whether there's a jurisdiction for them to hear the dispute. So if there is a dispute with regards to the interpretation of the body corporate's management rules or conduct rules, or the body corporate's resolution with regards to a specific dispute or matter, they can declare a dispute with a body corporate. They can declare a dispute, for example, with a homeowners association in the event a full title stands as well. And in that regard, that dispute will then be adjudicated by CSOS, or the Community Schemes Ombud. In the old days, what happened is if you had a dispute with your body corporate, you had to go to the deeds office. And in terms of Regulation 71 of the Deeds Registries Act, you had to get an attorney appointed who was on the panel and basically nominated by the deeds office to adjudicate this dispute. That has subsequently fallen away, and the responsibility has now been taken over by the statutory body called CSOS. It's very cheap to declare a dispute. You can literally log into their website by Googling CSOS. They will tell you exactly how you declare a dispute by means of a formal document. It's also much cheaper. You know, you don't have to pay arbitration fees, which attorneys normally charged, or are being arbiters charged, or mediators at an hourly tariff. I think I'm talking under correction, but I think it's 150 Rand to declare the dispute. They then basically decide in terms of Section 39, do they have jurisdiction or not? If they decide they do, they will appoint an adjudicator then to adjudicate the specific matter, and they will look into the specific dispute. So they're highly effective, and it's obviously another source of alternative dispute resolution. Now, for that purpose, you obviously have to pay. Somebody has to upkeep the statutory body, pay the salaries, pay the infrastructure and the like, and that basically the reason for the CSOS levy that you pay on a monthly basis. So it might be something that people have to become accustomed to and find out more, but it's really a worthwhile service paying for, and to make use of it. It's definitely an alternative dispute resolution other than going to court. And there is also case law that says that if they have jurisdiction, you cannot circumvent them and go to court. You obviously have to use the channels of CSOS only if you're not happy with the outcome of CSOS and the adjudicator's final decision, then you can appeal to court as an alternative measure. but it's basically your remedy of first resort.
So what it basically is like paying a small amount in terms of like an insurance, where if you need it, you'll just have to pay like a little bit of an excess, but then it's much cheaper at the end. Because what I hear you say is, in the beginning, when CSOS wasn't there, it was very difficult, and it was not a consumer-friendly thing to approach the deeds office and to go through that whole process. And it's lengthy, and it's not going to be easy resolvable. So what CSOS has done is probably what the rental tribunal also done is it made the load lesser of the courts, and it also made the process for you to resolve issues much quicker. And also just one question is, you probably also have to prove that you did try to resolve this with your complex instead of just running to the ombudsman. This is basically with any ombudsman, what you have to do is you have to prove, I did try and resolve it. This is the steps that I've been taking.
Correct. I think, well, first to slot in with your comment with regards to alternative dispute resolution, that's very important, because I think everybody has been privy to the fact that our courts are very congested. You know, we get a lot of court cases due to COVID and the like. We have been hampered with regards to finalization of trials and being awarded court dates. So the congestion of the courts just basically proves the necessity that we have for alternative dispute resolutions, like arbitration, and obviously to go that route. And like any other instance, I think it would further your case if you can show CSOS that you have exhausted the amicable channels. You've approached the body corporate or the HOA, you've tried to reason with them, you've tried to set up a meeting to try and resolve it amicably, and that failed. And then leaving us with a statutory body that has to make a call and obviously do it in terms of legislation and the alternative dispute resolution mechanisms.
You know, the last comment that I just have to make is sometimes we talk to people that are not like us in the business of making sure that you take the right steps. And I would just like to inform them, please note that when you engage in trying to resolve a matter, that you've got a good paper trail, because this is what will count, not verbal, or you have to make sure that even if it's via WhatsApps or emails, but you've got a good paper trail when you approach CSOS in this matter.
I think that's probably the most important comment that you've made. Like any specific claim that you might have is that there's always a burden of proof. Any law of evidence will tell you that he who alleges has to prove, you know, and the fact remains is that if you lodge a claim and you allege certain specific wrongdoings, you have to be able to prove that. And the only way that we found it to be successful is by having a decent paper trail. So if you foresee that something might end up in a dispute, it's always good compiling a file with your necessary correspondence, request a reply by means of an email or a written response so that the paper trail can be created. And that can obviously be utilized as evidence in the CSOS dispute resolution as well.
Yeah, so in summary, just to say that CSOS was created to make your voice count. And that's a place where you can be heard.
Yes, and I think in layman's terms as well, it's almost like the small claims court. You know, people get either truly upset or they get very anxious when attorneys and legal representatives are involved, because then it feels as if they are on trial, which I think they're trying to circumvent in this instance. You know, the small claims courts is basically something where you've got a presiding officer listening to both parties in informal terms. And I think CSOS is more or less the same. You know, to say, listen, let me hear your side of the story, let me hear yours, and then we adjudicate the matter and then make a resolution at the end.
Good. Thank you, Johan.
My pleasure.